Okay, we're on chapter 11, criminal justice and dispute resolution. And he's somewhat dealt with, as I asked, well, didn't ask him, as I asked the question, Nozick's objections, but I'm somewhat surprised he didn't deal with them by referencing Nozick directly. So they're dealt with, but I would have liked him to interact like with a quote, with something directly from Nozick. So first item that's dealt with is the integrity of arbiters. And he says the whole system would depend upon a contingent but robust fact about human beings and a wide range of cultures. That appeal to a neutral third party is widely perceived as a fair and reasonable dispute resolution mechanism. People tend to agree to a large extent on who constitutes an impartial judge. And then he goes, well, what if one side really wants somebody biased? Like, what if one side doesn't want to come to a resolution? And he says if the two parties do not both desire a peaceful resolution of their dispute, then they may simply fight it out. There's no need to propose a biased or corrupt arbiter in that case. He says an arbiter has one critical asset: his reputation for honesty, impartiality, and wisdom. And then he deals with the question of corporate manipulation and asks, wouldn't corporations manipulate the system by requiring employees or customers just to sign outrageous agreements? And he says, here's a more fundamental question. Why don't businesses make unlimited demands on employees and customers? Why not require customers to give the company all the money they have? Why not require employees to work for free? These arrangements would certainly be more favorable to the company than the sort of arrangements business actually offer. And then he goes on to analysis of prices, because he says the plan of making unreasonable legal demands is essentially equivalent to a plan to increase the price of one's product. And he shows how that would be basically selected out in free market competition. And he said the same principles apply to employer-employee relationships. There is an optimal wage for an employer to pay, such that if the employer pays more than that, he lowers his total profits due to increased labor costs. But if he pays less, he lowers his total profits due to difficulty in attracting desirable employees. I think with, the more libertarian-minded like myself, really what we have a problem with is that a lot of people will agree to things that we personally would find objectionable. And then we find it difficult to find a job or the job that we want requires things we would find objectionable, or one that doesn't require that. For instance, random drug tests. I don't do drugs. Like, I could pass a P test tomorrow. I'm not going to say I never have, but it's not part of my routine where I have to worry about random drug tests. But I find them objectionable. Here's the thing. Most people don't. Or at least enough people do that so many jobs require them. And he points out it isn't actually companies that are known to take unreasonable positions. It's customers. And they are more likely to take unreasonable positions and prevail than the businesses they patronize. And he says, well, what if people refuse arbitration? He says, if you reject the option of having your dispute arbitrated, your security agency will probably draw the reasonable inference that you're in the wrong according to prevailing norms, since the most likely explanation for your rejection of arbitration is that you expect any reputable arbiter to decide against you. I don't agree with that presumption at all. You might not want to arbitrate because you're convinced you're right and you don't want to compromise. Not that arbitration always means a compromise. I think mediation more implies that, but there could be other reasons. He said, for the same reason that protection agencies will not defend criminals, they will not defend people who reject arbitration as a means of dispute resolution. Now, that's probably true. And not because they think you're guilty, but because it's easier for them. And it's probably best overall for the anarchist society. Security agents will anticipate this eventuality, writing provisions into their contracts specifying the procedures that customers must accept for resolving disputes and absolving the company of the responsibility to protect clients who violate these procedures. And what it would take for those not to be a standard part of contracts is for people to rebel against it and patronize companies that don't have that in their contracts. Likewise, every social system generates unethical outcomes if the people who make decisions in that system have incorrect ethical beliefs and values. Garbage in, garbage out. Under anarchy, unethical outcomes result if most members of society have incorrect values, which will be reflected in the decisions of arbiters seeking to cultivate a good reputation with the public. In a government-based system, unethical outcomes result if legislatures, judges, or other public officials have incorrect values. This is not less likely to be true than that the majority of a society's members have incorrect values. So he does a really good job throughout this whole book saying pretty much, yeah, but what about you type of thing. You know, yeah, that might be true of me, but what about you? It's worse in government. He says, why obey arbiters? He says that sort of behavior, if anything, would be less tolerated by the rest of society than a refusal to accept arbitration to begin with. For the same reason that security agencies would not agree to defend criminals, you could expect your security agency to leave you to fend for yourself if you violated an arbitration decision. Now, next is the source of law. Now, this I find very interesting because we just have an enormous, crazy, and he deals with this at the end, amount of laws. So there's a lengthy quote here. In the status quo, the decisions of judges and juries are based largely on laws written by legislators or bureaucrats working for regulatory agencies. Since the anarcho-capitalist society contains neither legislatures nor regulators, on what basis could arbitrators make their decision? There would be two sources of law in the anarchic society. First, property owners or local associations of property owners could specify the body of law to govern interactions occurring on the property. Provided that all who entered the property were given fair notice of the legal code in effect there, arbiters would most likely honor the owner's choice of law. Legal scholars might develop suggested standardized legal codes, with business owners, landlords, or homeowners associations choosing which of several widely used legal codes should hold sway on their land. Consumers with strong objections to a particular legal code would avoid patronizing businesses that adopted that code. In choosing a home, individuals would weigh the advantages of the legal code subscribed to by the local homeowners association. The other major source of law would be the arbiters themselves. When the solution to a particular dispute was not determined by any law of the kind described in the foregoing paragraph, the judge would look to similar cases for guidance, attempting to apply the same principles in the present case that had generally been used to decide cases of this kind in the past. If the case before him had novel features, the judge would exercise his own judgment to devise a resolution that seemed fair and in keeping with the generally accepted values of his society. He would then write an explanation for his decision, which would be added to the body of precedent for other judges to consult in future cases. It makes sense for arbiters to follow this tradition, since it usually results in decisions that most observers regard as fair, and it preserves the sort of consistency that most observers value in a legal system. And, he says, judge-made law is more flexible than statutory law, and the common law system makes far smaller cognitive demands on the individual lawmaker. It says, and he lists multiple countries, including the U.S., and said, most of contract law and tort law is judge-made common law. Most of the criminal law was also common law prior to the 20th century, and the anarchist society, given the absence of statutory and regulatory law, common law would play an even greater role than it does in these countries today. So we do have a past precedent in common law. All right. I do these 10-minute blocks at a time. You'll see me put a different outfit on when we continue. Okay, continuing. So, punishment and restitution. The anarcho-capitalist justice system would most likely focus on restitution rather than punishment. That is, criminals would be forced to pay compensation to their victims. I have to admit, while logically all of this makes sense, it brings up images of forced labor camps, and I don't think sometimes I can't put into words an objection that I feel. But just like in libertarian theory, that specific performance isn't considered a contractual, if you violate a contract, like if you have a contract to marry somebody, you can't be forced to marry them. I'm not so sure that it's a libertarian solution to, say that you're going to put somebody in a prison camp. They can have a judgment against them. There's, you can seize property. But I'm not down with this idea here of forced labor. He's going to bring this up multiple times. I suppose someone can choose to make their restitution that way. Like, there can be choices. But this part I'm not particularly down with. Now, I know we've even had that in this country, and perhaps it's the history of that. I mean, remember it literally was true, but it's become almost a trope, where the prisoners were making the license plates. It says uncompensable crimes. So what would happen if a criminal lacked the funds to compensate his victim? One possibility is that the criminal would be remanded to a private prison where he'd be required to work off his debt. Okay, I've already said my comments on that. Just want to read his work here. So then it talks about, and I don't agree here, obviously, either I'm ardently anti-death penalty, but it's saying, what if you find someone like Ted Bundy? He said there would seem to be two options. He can be imprisoned indefinitely, probably in a forced labor facility, or he can be executed. Again, it would be up to the arbiter in the case to determine the best course of action. As in the case of the real Ted Bundy, execution appears to be a likely possibility. No. So, the next objection he brings up is excess restitution. Say, well, if these arbitration providers aren't motivated to protect criminals, there's all the reasons why he said that wouldn't be the case, that they'd be more biased in favor of non-criminals because more of us are non-criminals than criminals. He said, what would stop them from being, biased extremely that way and awarding excess restitution? And he gives some reasons why he doesn't think this would happen. He said, 1, the argument unrealistically assumes that actual and potential crime victims favor unlimited compensation. 2, Birch, who's an objector, imagines arbitration companies advertising that they award excessive compensation, announcing, for example, that they award each victim compensation equal to 10 times the loss the victim has suffered. This is very close to a court's explicitly announcing that it is unjust. He says this is a possible problem with the system, but it is not a terrible problem. Moreover, it is plausible that over-punishment occurs also in governmental systems, and it's not obvious that governmental systems deliver more just punishments than those that would emerge from an anarcho-capitalist system. And he said, apart from their concern for the rights of criminals, which admittedly is limited, there's another reason for ordinary individuals to oppose absurdly excessive compensation for crimes. In any realistic criminal justice system, innocent people are sometimes convicted. Said excessive compensation awards also tend to be more difficult or expensive to collect. Next, a criminal who is wronged by a clearly excessive compensation award would seem to have a valid complaint against the court that made the unjust award. There's no obvious reason why he could not file a lawsuit against that court in a different court. Even extreme increases in the penalties for crime would not eliminate all crime. Consider an analogy. As automobiles became more practical in the 20th century, the demand for horses suffered a drastic drop. But the entire industry did not collapse, nor was it monopolized. There remains more than one horse breeder in the world today. The industry simply shrank to the size that could be supported by the new levels of demand. Likewise, if we should be so blessed as to find ourselves worrying about unduly low crime levels, the arbitration industry will shrink, so that includes only the number of courts needed to satisfy however much demand remains. Next section is the quality of law and justice under essential authority. And he goes, before you lob all these criticisms at an anarcho-capitalist system, what about the system we have today? And he says we have to consider the flaws in the present system. One thing he mentioned is wrongful conviction. I think we're all very well aware of that. The next thing was the oversupply of law, that there is just too many laws that the average person cannot possibly be expected to know it. And then next, he said this criticism is normally against an anarcho-capitalist system, but it's more true in a governmental system, and it's the price of justice. And this is where we'll pick up in my next installment, since we only have a little bit left, and I like breaking these up to keep fresh. Okay, last installment, and yes, my hair is freshly pinked, with the price of justice. For most citizens of modern states, the costs of government justice in both time and money are prohibitive. What did I say? Prohibitive. The typical civil dispute requires anywhere from several months to a few years to resolve through governmental channels. In 2009, the average law firm billed $284 an hour. Now, in big cities, it's easily $400 plus an hour, with a typical divorce costing between $15,000 and $30,000. To the average American with an annual income of $39,000, any use of the government's justice system represents an overwhelming financial burden. Why are legal services so expensive? One reason is the oversupply of law. The complexity, technicality, and sheer length of the laws and legal procedures forces individuals to pay experts to handle, and it forces those experts to expend a great deal of labor on each case. Another reason can be found in the restrictions on the supply of legal services, which by law may only be purchased from government-approved sources. These costs are troubling for at least three salient reasons. First, the high cost of legal services means that only the wealthy can afford justice. Middle and low-income individuals cannot afford to seek justice or must take justice into their own hands when they believe they have been wronged. In criminal cases, low-income defendants may receive inadequate legal representation due to heavy caseloads on public defenders. Second, even defendants who win their cases, whether the cases be civil or criminal, may be financially ruined. This acts as a kind of unjust punishment imposed upon all defendants, whether they are guilty of wrongdoing or not. Third, large businesses may be able to afford the legal fees necessary to ensure compliance with complex bureaucratic regulations, while the same costs may prove prohibitive for small businesses. As a result, the present legal regime tends to promote concentration of industries in the hands of large corporations, even if those corporations are in themselves less efficient than smaller firms. So the cost of justice under government systems is not cheap. And then it says, because this is going, actually this goes to this section called Reform or Anarchy. Because government collects its revenues in the form of taxes, which citizens have no choice but to pay, government programs can survive financially even with extreme levels of consumer satisfaction. More importantly, because government is monopolistic, citizens have nowhere else to turn if they find its services inefficient, of low quality, or abusive. So that is the end of that chapter. We are getting towards the end of the book. The next chapter is entitled War and Societal Defense. Let's look as we do at how many pages this is. Let me see. It's longish. 31, not too bad, but that's what we'll go to the next. And then after that is the last chapter, which I'm really looking forward to, called From Democracy to Anarchy.